decade now, and they'll be able to provide you with some insight in their experience and what we can do to utilize, although I guess I've been assured by the department that our new system will not be quote-unquote privatized, but I think we'll run into some of the same concerns, you know, both whether it's negative or positive experiences, and I think we'll be able to use a lot of the judges' comments and insights into smoothing the transition into our new system. Judge Jean Shepard has been a Kansas District Court judge since 1984, and she's the chair of the Supreme Court Task Force on Permanency Planning in the Kansas Judicial Council. She was formerly a member of the Court and Education and SRS Liaison Committee and started the first Citizen Review Board in Kansas. She is also a dual case planning and case management trainer for the National Association of Juvenile and Family Court Judges. I apologize if I keep looking down to refer to my notes. I've got enough judges to introduce today that I couldn't memorize all this stuff. Judge James Burgess is the presiding judge in the Juvenile Department of the 18th Judicial District. He's been hearing juvenile cases exclusively for over 20 years. I believe all of our judges from Kansas today are Washburn graduates with their Juris Doctorate. Judge Shepard, it doesn't say that on here, is it? Okay, I'm sorry. Anyway, my apologies. Judge Burgess has been on is a member of the United States Coordinating Council on Juvenile Justice and Delinquency Prevention. He's also on the Supreme Court Task Force on Permanency Planning and the Sedgwick County, Kansas Juvenile Justice Advisory Committee. Judge Burgess has spoken on numerous occasions about juvenile justice to many various presentations, including the Drug Advisory Council on National Leadership Forum, the ABA Young Lawyers National Conference, and the Midwest Legislative Conference. Judge Daniel Mitchell, a Washburn grad, was in private practice until 1985 until he was appointed to the District Court in Shawnee County, Kansas. He is active in numerous advisory boards and committees regarding children and or law, including the Kansas Supreme Court Task Force on Permanency Planning. Judge Daniels is also an adjunct professor at Washburn University School of Law. And Judge Robert Bednar received his degree from Washburn as well, and undergraduate education. Served in the U.S. Army am I saying this correctly? The BROM? Or not a typo. It says served in the U.S. Army BROM. Forgive me, I'm not familiar with it. I'm assuming that is a typo then in the email I got, so.
No, it's top secret.
Yeah, good call. Thank you. From 1969 to 1971. Was in private practice from 1973 until 1998. Until he was, well, you know, with those acronyms, you never know. From his private practice from 1973 to 1998, he was appointed to the District Court of Atchison County, Kansas in '98. He does a lot of juvenile offender and children in need of care in domestic and family law, and some limited and small claims cases. So with that, I will hand the mic over to Judge O'Neill. We can begin with the moderation. I think that is our only mic.
I think it is, so I'm pretty loud. So, well, welcome everyone. It appears that there is a high degree of interest in privatization and how that's going to affect the court processes here in Nebraska. And we are privileged to have the judges from Kansas here today willing to share with us that expertise and their experiences regarding the privatization in the state of Kansas. This is going to be an informal session. If there are questions that come up during the session, please feel free to raise your hand and ask the questions. We want to make this as informal as possible. So I'm going to start out with just asking a general question. What is your general impression of the impact of privatization in Kansas, especially as it relates to the state's responsibility to provide reasonable efforts to prevent removal? Anybody want to take that one on? We knew Gene would do that, so.
These guys have been mean to me all morning. It doesn't change the state's responsibility, so I would say there is no impact. The state is still required to provide reasonable efforts. Courts are still required to review cases to make sure they're being provided. If they're not, the court makes a no reasonable efforts finding. There is no difference from my perspective as to whether those services are provided by your state or by a private contractor. The state has custody, the state's responsible.
Does that change at all through any part of the process, whether it's reunification or any of, you still see that as the same?
Absolutely. And it's an interesting dynamic, though, to see how the contractors and the state agency work. At the supervisory level, the state understands, yes, we are in charge, it is our contractor, but we often have the experience at the worker level that they don't get it, that they have the ability to say, contractor, that's not what we want, change it. And they feel that the worker level, I think sometimes they say, well, the contractor decided to do it this way and I didn't have any choice. Yeah, you do. You're the state agency, you're the people who have the contract, you can tell them to do it the way you want them to. And I think that was kind of an educational piece for a lot of our folks to understand that we are going to hold the state responsible, and if we're going to hold you responsible, you better make sure they're doing it the way you want it done.
Has there, and this I'm going to ask kind of a sub-question here, has the use of no reasonable efforts findings increased since the time of privatization in Kansas? Have you utilized that more than you did in the good or bad old days, respectively? Anybody want to?
Well, with respect to my particular venue, at least, there was a increase in no reasonable efforts findings initially until the message was recognized and received about responsibility, and then it has gone down. Most of the time now we have reasonable efforts that are being provided without the court having to drop the hammer, so to speak, to get someone's attention.
In my case, I've only dealt with privatization. It came into effect at approximately the same time that I took the bench, and yes, the no reasonable findings is something that's extremely important to the judge. It's what you use to get their attention when they are failing in their responsibility. What Judge Shepard and Judge Burgess mentioned with the initial question, you are not party to the contract. You deal with whoever you place the child in whose custody. If you're placing the child in the state's custody, that's who you hold responsible. As to how they deal with the private contractor, that's their business. But you deal with whoever you place the child in your custody. And the no reasonable findings are quite necessary.
I have to say that at the beginning of our contract, it was really chaos. We did not have a transition period. There was not payment for that transition period. So there was a magical date when all of the case files went from our agency to the contractors. And then the contractor was supposed to be responsible. And we had contract workers in court who hadn't had time to review files, who never testified in court, who had that deer in the headlight look. It was not a pretty thing. But from the court's perspective, those cases were set for review. Someone needed to be there who knew the case, and I expected to have a review. So that initial time period was very difficult. There were no reasonable efforts findings, but I would concur with Dan that those have decreased and are pretty much at the same level that they were before we went to privatization.
Now, one of the things I think would be interesting, we talked about before this meeting, was that in Kansas, would I be correct in saying that each of the regions has one contractor to deal with? Is that correct? that unlike Nebraska, which will have 3 or 2 contractors depending upon the region, you had a single contractor for to deliver those services. Somebody want to talk about that for a moment?
I'll initially take it and then pass it off again. Initially, under our contract, we had a family preservation contractor, a foster care contractor, and an adoption contractor. That has evolved. The next contract, the family preservation contractor kept the case all the way through. That did not work so well for us. And having a separate adoption contractor really did not work so well initially, because that contractor ended up with all the kids who'd been in foster care forever and were really old and going to be difficult, they had mental health issues and all kinds of things. And the contract was set up so that the adoption contractor only was paid for a set period of time, and that contractor really took it on the chin with that particular group of kids. Now we have a family preservation contractor and then a foster care contractor who keeps the case all the way through adoption, and then someone who recruits adoptive homes.
I would say that at the beginning, this kind of relates back to the last question, there was a huge learning curve, both for us and the contractors. And we sat down immediately and started talking. This is working, this is not working. And it was a very informal operation. Once a month we sat down, we would go through the cases that went through our last docket and said, this report didn't work, this is really not what we wanted. And we got a really good line of communication very quickly, and our contractor, which luckily I've had the same contractor all the way through, I think these guys all had different contractors, we've got a good line of communication. So starting over a decade ago, we're still doing that, meeting one time a month and just talking over things about what's working, what's not. They've been very good at adapting to what we need, and really good, we've had good training opportunities. So the ability for me to work with one contractor has been very, very beneficial. I can't imagine the chaos you'd have when you just flip one of these contractors on July 1 and say, okay, you've got a new batch of people to deal with. I'd be very lucky. But I would really suggest nothing that you are going to do is going to be what you planned, to a certain extent. I've got an 83-year-old father-in-law who's a Marine, and he comes up with these Marine things all the time. One of them he told me was, no battle plan ever survives initial contact with the enemy. You're going to have this great plan, and you think you're going to thought of everything, you won't. In foster care situations, child protective, there's a myriad of things that you never expect. You're going to have to adapt. So you've got to work with your contractor. You've got to open that line of communication. You've got to be very clear from the bench what you expect, what you need to make good decisions, and they've got to be able to provide that for you. So whether you got one contractor, 2, 3, you've got to establish that line of communication with all of them.
Who attends your hearings? Is it both a representative of the private contractor and the case manager? How does that work in your respective jurisdictions?
Well, as far as my caseload is concerned, I, up until recently, had a representative from SRS, our state agency, had a supervisor from the private provider, and a caseworker from the private provider, all present in court. The economic shortfall that is affecting Kansas, and I'm sure it affects Nebraska as well, has caused a reassignment of the SRS worker who was attending court. I contacted the secretary, and we worked out a deal where there is a hotline, a number that I can pick up from the phone on the bench and call and get immediate response if an issue presents itself. But it affords the agency not having their representative set there. That's a compromise that I was willing to make. I'm not sure it's as efficient as when the person is actually there and can observe what the circumstances are in the court, as opposed to being called by the judge, which sometimes puts people ill at ease when the phone rings. Why that? But I do believe that the people that need to be there obviously are the prosecutor, the guardian ad litem for the child, parents, attorneys, the caseworker for the contractor, the supervisor for the contractor, and the ability to have contact with the state agency who is the legal custodian of the child. And just to digress a moment to what Jim was saying about his monthly meetings, I've done that as well. We call it a provider's meeting, the first Friday of every month. And it will save you a significant amount of time, and it will enhance the delivery of service. It is well worth the time or effort, whether you do it over the lunch hour or do it before or after normal court hours. It is a good investment of your time. A lot of things can get resolved and make the system function. Anyone that is participating in the delivery of service as far as the children and the families are concerned. I have all of the representatives that normally appear in court, as well as other providers who do therapists, special education individuals show up. It's open to anyone who has an interest in the aspect. It's not a required assignment, but it is open to anyone who may have an issue with how things are functioning in the delivery of services to a child or a family.
Ours is somewhat different. We have all the judges, our social rehabilitation services, SRS, foster care provider, and our family press contractor. Those are the people that we have other meetings that include the people Dan's talking about, but our contractor meeting is just those people who are really providing the reports to the court, who have custody, those types of things.
Now, do any of you have actual case workers or whatever the term of art is from the department, from SRS, at your hearings along with the contractor?
We did from time to time, and it's especially true when I was in Leavenworth, Kansas. I came from a district that has 2 different counties. And normally we will have caseworkers. Not always will we have the supervisor of the caseworker. We had a liaison worker from the state. And from my personal perspective, I think that it's necessary to have a representative of the state agency there also. Everyone doesn't agree on that. There is some problems with people, but everything flows much better and is much more consistent if you have a representative of the state there rather than a caseworker. And maybe because of the problems that's been described, like I've had 3 different contractors now. I started out with one, spent 8 years with a different one, and I've got a new one now. That contract went into effect July 1. We still have people who do not know what's in the files. Just because of the turnover, new personnel, different things of that nature. And you need a state representative there to explain to them that it's their responsibility to provide the services to the child. And you just can't say, I'm new, I don't know what's in the file.
Who puts together the reports that come to the court as far as helps the people? In Nebraska, we call it health and service case manager.
Caseworker
They put a couple together from the contractors.
no, the caseworker is a contractor.
Caseworker who's actually working the case, not the supervisor. The actual caseworker provides the report.
They will at times submit it to SRS and they'll have a cover sheet.
And the question is, what's going to happen to our state caseworkers? They got to become.
Well, in our district, they became investigators, which meant a huge glut of cases. But as it has turned out for us, that has been a good thing because now I've got investigators, but they are also doing pre-filing services, which is our case numbers going down.
I think that will do over lunch, actually, when they do their presentation of the report.
I was going to toss out that I only make SRS, our agency, come to permanency hearings, but I do expect them to always be there for permanency hearings. And when we first had our contracts, all of the reports went to SRS, they reviewed them, and then they came to the court. That step has been eliminated. And we also have a family-centered systems of care meeting once a month, and it is run, it's our mental health center. is instrumental in setting that up, but it's everybody involved in kids' issues comes to that, and it helps to have that communication with the mental health providers.
You know, other than the use of the no reasonable efforts finding, if you are having problems with a particular case and a contractor, how do you make it known to the department that you're having those problems short of doing a no reasonable efforts finding? That question makes sense? They've got a problem, they're not doing something they're supposed to be doing. How do you get to the ultimate custodian short of doing a no reasonable efforts?
Well, I suppose you could set up for another hearing. I don't call up and chat with people about particular cases on the phone. I think that's not appropriate for a judge. But that's just the way my district is. So I might set it for a quick review with a subpoena to the secretary to have everybody in court to hear about it. But I'm not going to call someone. I think probably other people here may have a different method of handling it.
In the most egregious cases, we've cited them, and that'd be the secretary, or it could be a local representative if he felt they were intentionally violating the order.
But what we found with having a contractor supervisor in the courtroom, and I have an SRS liaison, and all four of my SINC judges, child need care judges, have a SRS liaison. If something is going on in court, by the time I come around to my next monthly meeting, that's usually already been discussed, and I'm not having to tell them what the problem was. They're telling me what they've done to solve it. So to have those people there to see the problem is very helpful, and they're well on their way to getting it taken care of. But if for some reason it hasn't been addressed, it hasn't percolated up to the top, that monthly meeting is where we talk about it. This is what went wrong, this is what we need to do to fix it.
What's been interesting to me is that the agency is much less tolerant of the contractor not getting things done than the agency was of itself. And the contractor has money on the line if they don't make the changes. I just made a no reasonable efforts finding, which was entirely the state agency's fault. They decided to audit files at the time they were being transferred, and the new contractor didn't get the files. Really a strange time to do an audit. And you have to make it real clear that that no reasonable efforts finding related not to the contractor, because that contractor is going to pay the price. If the fault really lies with the state agency, you need to push it back a step. But I've found that they are much less tolerant of things not getting done.
One thing I think you will find is that the private contractors, if they're not familiar with the court system, will do just what Judge Shepard indicated she doesn't want, and that is they'll try to contact you directly. And it's something that you have to head off because they will constantly be calling, well, what should I do, or what, and you're not their advisor. You know, in that respect, there is a court order that they should be following, but they love to try to contact you directly.
Do you have any suggestions for judges to manage those hearings on those issues you kind of talked about, where people have varying degrees of knowledge about the cases? And anything that comes to mind?
Well, I think one thing that you're going to be helping yourself tremendously is if you sit down, judges, and do some training with your contractors. This is what I need. Talk to these people. These are my perspectives. These are my goals. This is how I'm going to get this job done. And one thing, at one point, I had some workers who just saw an order and said, "Oh, gee, we didn't think that was necessary." That looked really well. And so you got to make it clear, no, that is the court order. But if you can come to me and make a case and explain to the judge, we don't need to do this because of these facts, I'm good with that. So, you know, you really got to get your people on board of explaining, these are your orders, this is what we expect. When you're out there in the field, you should know better than me about what's going on. You present the case, and if you back it up with facts, I'm with you. but you're gonna be way ahead of the curve if you can sit down. In my group, like I said, I've had the same contractor all the way through. Each judge has their own team of workers. And so I sit down with my own team, sit around, have some pizza, I talk about what I think the system is doing, what it needs to do, how the role they play. And of course I have to do this every so often because there's new workers coming in. But it really is a valuable deal. If they understand where you're coming from, you get that training ahead of time, make your expectations clear.
Do you have any, I'll get you in just a second. Do you have any issues where the agencies have been pointing, well, this is the SRS's responsibility, this is, and SRS going, this is the contractor's responsibility, and that accountability piece that I think a lot of people have trepidations about here in Nebraska?
Not now.
The agency is the one that has the responsibility. The child is placed in the custody of the state social service agency. It is their ultimate responsibility to ensure that the services that are necessary are provided. Period. It's not the work, it's not the contractor's responsibility. The contractor owes its obligation and responsibility to the agency. The agency is the custodian and owes the responsibility to the court. So when something goes wrong, I'm talking to SRS and saying, fix it, get it under control. You're the one that's legally responsible. Again, no reasonable efforts or contempt citation will bring somebody to the table quickly.
Question over here.
I actually have two.
Okay.
Apropos of the providers meetings, do you ever do after-action reports on closed cases? We did really well on that. We kind of booted this one, et cetera, et cetera. And two, when the system comes in, did you have the experience of seeing an expanded role for guardians ad litem? A lot of my colleagues are thinking that maybe guardians ad litem are going to be a little more of super case workers. Did you have that experience? Those are my two questions.
I think that, I'll take your last question, which I think that everybody involved in a case had to become more active initially. And that would be our CASAs, our Citizen Review Board was doing more review hearings, for reviewing cases more frequently. I was reviewing cases more frequently, Guardian, and everybody, the guardians ad litem, the DA's office. Everybody was busier than they had been initially, just to get things up to speed. I did want to say our contractor's been the same for the entire time. And it is KBC, and I know they're one of your contractors here, and they had trial by fire, and they have, I think we all agreed, have done.
Fire.
Yeah, so I know that you all have no idea who they are, but I think that they're going to be fine. I just want to reassure you of that.
In fact, you people stole who ran my foster care agency in Wichita, and I'm really pissed off about it.
Next time I come to Wichita.
Well, if she comes up missing, Sandra.
And we have not talked about, cases later about open right, which might be a nice thing to do. We do have a really good aftercare program built into the contract for a 12-month period after kids go home. And we were talking today about how that has reduced the number of kids who return to custody enormously.
But I think that does vary by contractor, how intense they work.
Jeff.
I'm going to put you on the spot. For those that were around before privatization, now, is it better or is it worse, generally?
Initially, it was chaos. Now, I believe the reality is with the time of 12 years approximately, and the understanding of what the contract requirements are, I think the state is probably getting a better bang for its buck than it did when the state was running it itself. That's my concise perspective.
And that's more of a statewide perspective. Our judicial district, probably because of the university and its location, was just really rich in service providers. And when privatization happened, initially the contractor was going to do all of those services internally. And we really, I think in many ways, suffered because of that. And we are now returning to that situation, and our contractor does contract with other entities within our community to provide services. They're not doing everything internally. I don't know how they're managing financially in our district, but we're where we need to be, I think.
And I would say there's a couple things that I've seen is, first, since all those SRS people became investigators, we had a glut. It was described as a pig in a python, and we had to really work through that. But now we're in a situation where our cases are getting investigated more timely. We used to have a priority system, A, B, C's. A's got investigated, most of the B's, probably none of the C's. Now they're all investigated. Plus, we've developed to the point now that, you know, we've worked through all those issues of just, you know, who do we talk to, how do we get things worked out, and now our agency is very active in being proactive. They're working on trying to find evidence-based practices. They're trying to find ways to do things better, and they're bringing those to the court and saying, hey, here's what we think we're going to try, and that is a really good thing. I think we're trying not to remain static. We're trying to improve that, and I think they've been very active in trying to find better ways to do things.
And I have to agree, my number of cases is down. We've closed a lot of cases. Adoptions have been finalized, a lot more adoptions, so that part of it is good. I think having a separate entity for a while focusing on adoptions was good because, as we know, the squeaky wheel gets the attention, and often it's not those kids in pre-adoptive homes. So this helped. There's financial incentives to move those cases forward now.
I think one of the things, so in answer to your question, both these judges have the same contract. It makes a tremendous difference if you have consistency, lack of turnover. I've been through 3.
Our contractors like this.
Or no one else wanted it.
One to the other. One to the other.
But it does make a tremendous difference because every time that contract changes, you go through a transition period where the services are being provided to the children on the basis that you hope they would be.
Pat?
I have a mechanics question in terms of actually handling the hearing. Now, most of our counties, the county attorney functions in essence as the attorney for Health and Human Services at review hearings, at disposition hearings, unless they don't agree, and then the department will bring in their own attorney to represent them. But if you don't have what would be our HHS worker, and maybe that's not what we're going to do here, how does a county attorney even offer a case plan in a situation like that? Mechanically, if the case plan is coming from the provider instead of from the agency that's got the ultimate responsibility? Because he or she is not representing that provider.
If it helps, we're not going to do that.
Good. So you're going to have a caseworker there. That takes care of that.
Well, the deal is, whatever attorney's sitting in there, for us, they're representing the state of Kansas.
Yeah.
They're not representing SRS, they're not representing that agency. They're representing the state of Kansas. And
Not exactly that way here.
Well, the action is brought by the state parties, the interest of the child. And the district attorney or the county attorney, whoever prosecuting the case, doesn't necessarily walk in lockstep with SRS or the contractors. That's not their job. Their job is to pursue the legal aspects of the case. Social aspects of the case are dealt with by the state agency and the contractors. And they will, if need be, present with their, I've had contractors bring their attorney to court. If there's an issue, if we have a real issue, we set it for hearing and we get it resolved.
Well, we literally have a situation where if the county attorney doesn't agree with the case plan, then the county attorney notifies the department, and they bring in their own attorney then to participate in the hearing and present the evidence for reasonable efforts and to get the case plan adopted.
Now, we had some questions over here about whether you think it's better or worse since privatization. None of you are from the more rural counties of Kansas, but given what your understanding is, how do you see privatization affecting the level of services for the rural counties, maybe particularly western Kansas, which is not dissimilar from western Nebraska?
You know, I'm probably from the smallest county before judges, but I don't think privatization affected the services because the services that are available in the rural areas, they are what they are. And the private contractor has to deal with those that are available, the same as if it was an agency dealing with it. Just because there's a private contract, that didn't necessarily add services or
I think part of
providers.
what I've seen the contractors do is when they saw gaps, they've had to be creative and say, okay, how are we going to fix this? For some time, some of these folks, it was transportation. They worked with somebody to provide no-cost clinical assessments. So their case planning wasn't necessarily how are we going to get this particular case done, but it's how can we make some services available. I've had that experience. I don't know what the same in the counties.
You know, I've had that too, but what you run into with the private contractors, they'll say the foster family is to provide transportation, etc. They'll say that is their job. We will give them a gas voucher. We will provide this for them to do it. And they want to shift the responsibility of getting the child to, whether it be medical attention, mental health, they'll shift that. And you may know it or you may not know it, depending on, you know, how in-depth your reports are as to who's actually doing it. You may just see a report where the child didn't attend, you know, for certain reasons, but there is a shift in that with the private contractors.
Is there a question over here?
Well, and your question goes to the Kansas judges, kind of was the basis of my question, but I guess with regard to rural services, because the private contractor is then obviously under contract and getting paid, you know, we've had some issues where it's all been under the umbrella of HHS, where private, and they go to private providers as part of their, you know, attempting to provide services. The service provider will say, well, we won't travel but, you know, 25 or 50 miles away from wherever they're at. Now with the private contract, have the service providers been more willing to expand their range of where they will provide to, because, you know, they're getting paid and they're under the contract.
I think one issue that and that's a huge region, the whole western half of the state essentially is one big region. And I think they have had difficulty hiring staff, which I think was true for the department before that happened. And some of those things have not changed. So I don't know if it's made it any better or any worse, or if it's the same.
In answer to your question, I've been told time and time again by contractors, we won't travel over 30 miles to transport. And we get into a dispute with them over that as to whether well, we're going to issue an order that you provide the transportation, you know, from point A to point B. But they have a transportation limit in most of the privatization contractors that I've been associated with.
How can you order somebody that's contracting with the state?
Because you're just ordering SRS to provide that service. You're not ordering a private contractor.
But I've seen contractors, though, in our situation, we needed a parenting class or an anger management. They develop those in-house. So our contractors have done that. So maybe a parent can come to a visitation, stay for a parenting class. Come to visitation, go to anger management. So to a certain extent, where there were gaps, they developed their own. And I don't know whether they've done that in the rural districts or not, but I would hope they would.
What's happened is, with some of the gaps that, like Tim's talking about, is the first district I worked in, we had very few foster homes. It was a district, even though it was a larger district, they could not develop them, and they made every effort, every contractor did. So as a result, every child was going out of county, which meant transportation issues every single time, whether it be simple visitation, Could they continue with the same therapist? All of these are problems that you're dealing with if you do not have a strong base to keep the kid local.
Was there a question back here in the, ma'am, in the, Jackie Fuller?
I was just wondering, like, how long did that learning curve take you? Was each new contract, or when you started it, 6 months, a year, 5 years? Like, you get lighted into the tunnel, but how soon is that? How long is that tunnel?
I would say, from my perspective, at least at the initial outset, and anytime you do a change in the contract, it will take from a year to 2 years before you're really at what you would consider, or what I would consider, an efficient operation. It simply takes that amount of time. Now, it would be more beneficial to everyone if it could be done quicker than that, but the reality is, depending upon the amount of cases that you have to deal with, the severity of the cases, and the resources that are available, the transition will take some amount of time until you get the system in place and functioning as you would hope it would function.
And I would also say that that will depend on how well you can communicate.
Yes.
With your, if you've got people who are really willing to come to the table and talk, these are our problems, these are our solutions. But I think you'll find even after you get, the first thing you're going to see, the light at the end of the tunnel, is going to be a train coming at you. You just get hit by the train, get it over with. But the thing about it is, and I want to emphasize, it's an ongoing process. It's adapting, it's changing, and if you get set in your ways, you're not getting better. That means you're probably getting worse. So it is a deal that you need to continue that communication, get through the learning process, but continue to communicate, continue to improve.
There's going to be a turnover in the personnel, both from the contractors, from the state agency, from the court system. There will be, all of us are long of tooth up here, and some of us are talking retirement, but there will be someone else who steps in to pick up the caseload and move on. So it is a continual transition, and communication and cooperation are necessary to make the system function as best it can.
Initially, one of the interesting things to me was that our state agency, the line workers, the caseworkers, didn't exactly understand their function, and were pretty happy to have handed those files off and kind of went King's X. And they really were not playing nicely with the contractor, and were not doing, I don't think, what needed to be done. So I think part of what needs to happen at your initial transition is the state workers who have been responsible for the cases really working with whoever in the contract is going to take that case over, and communicating and personally sharing information, and not just handing them the stack of files and walking out the door.
I would suggest a couple other things. We have a group called our Permanency Council in our district. And one thing they do is interagency training. Everybody, SRS, the contractors, school district, we come in on issues that are relevant to everybody. So we have one common training and we're all on the same page. That is a huge deal. Second of all, we have a group called our Operations Board, where it's made up of all line workers who they are identifying the problem areas and saying, okay, what do we need to do to make this better? And then they can bring that back to us, who are the decision makers, and we can do something about that. But that common training is a huge deal. When I first started, I would have school teachers telling kids, if you do not behave in class, Judge Burgess is going to come down here and arrest you. You can't do that. But they thought I could. But I mean, it was that fundamental. They didn't know what we could do. We didn't know what they could do. Now we do this common training, and we're all on the same page. We know what we can do and can't do. For example, all of our runaway kids, the child needed care workers wanted us to put them in the detention center. We can't do that. We can't pull that off. Here's what we can do. And so as a result of that, we understood what we could do. We started working on ways to address that and to make that better. But that common training, same page, and percolating up those problems from the ground up, I think it is a good. are good things to know.
I just want to people wonder, you've been at this about 12 years, is that correct? And the contracts have been 4 years long. Do I understand that correctly?
First one was 2.
First one was 2, and now you've had 2 4-year contracts. So those of you who have been, and you kind of touched on it, but I just wanted to emphasize this point. Those of you who have had a single contractor versus those of you who have multiple, is there a real difference in how the outcomes have been based upon the changes in the contract? That question makes sense?
I don't think that the outcomes have varied significantly, other than it's not been as consistent. You have to change the contract. Jim's fortunate when you have the same contractor, you've got the case or the program in place and things are working well and you build upon it. There is that period of learning, that learning curve when you get a new contractor in, and as much as they may ask for and get benefit and assistance from the contractor who is no longer having any responsibility, it is a period of acclimation. It is a period of change. That's why I said in my circumstance, at least, it's usually a year to 2 years before the new contractor is really at the same level or at the efficient level that the court would like to see. And that's a huge time frame in the lives of children, but that's reality in the transition.
Pat?
Oftentimes we have a problem in this state because of the turnover as far as case managers are concerned. Either burn out or they transfer to someplace else. Has this made a difference as far as both your SRS people are concerned, and do you have more continuity as far as the providers are concerned so that you don't have turnover there?
I think that depends on the provider. Our provider who's been in our district the entire time seems to have really good employee stability. And our state agency does. I know you find this hard to believe, but a lot of people like to live in Lawrence. So we don't have some of the problems that other places have. I do want to say that, talking about this transition thing, it is really scary for kids. And those of you who are dealing directly with kids need to be aware that as kids get older, they know this privatization thing is happening. It really scares them. They don't understand what it means in their lives. They think they're going to get moved. They think they're going to have all kinds of bad things happen. And it's really important to work with them during that time frame. And I think every time you change contractors, there's some of that sort of disorientation among those older kids who are more aware, and it comes from their own providers, from their foster parents, wherever they are. So every time that happens, it stirs those kids up again, and people just need to be aware of it.
But realistically speaking, you've got your SRS workers, now you've got your contractor workers, that's in the whole other line of workers. I've been told that every social work graduate in the state of Kansas could be hired every year to fill all those positions and that type of thing. So there's a huge demand for good workers. We're pretty stable at our SRS level. We have some turnover at our contractor level, and they work really hard to try and maintain that. But there's just a huge demand for hiring social workers.
I think that initially in the contract, when you go through a change, there is a turnover. And that's with the private contractor, and that's been my experience. The longer a private contractor holds that contract, the less turnover, more stability. But if it's changing every 4 years, you're going to have turnover because people really don't know what to expect with the court system, and they find themselves in a job they really didn't want to do.
Jerry, do you have a question over here?
Well, the question still goes back in my mind is on the case plan and court report that we did at reviews or other times, who signs off on it? Because now I can look at the front of it and I can see who the social worker or the case manager is, and so that person normally is there to testify. Because there's issues that you may have parental or parents' attorneys say, we don't have that person here to testify. How can we get that into evidence?
They're listed on our reports. I mean,
okay, so
they say who wrote the report, But isn't that's usually the caseworker we have in court unless there's an
And
emergency.
supervisor.
Supervisor.
Okay. All right. As far as lawyering goes, whether it's parents, attorneys, guardians ad litem, has there been a change in the way that attorneys have done business since privatization? Do you see any difference in their roles, whether it's expanded? Anybody?
I don't think that the role of guardian ad litem has changed that much. Guardian ad litem's responsibility is to represent the best interest of the child and to do whatever is necessary to accomplish that goal. So that, whether or not you have a change in contractors, it may be a circumstance of the guardian ad litem having to reestablish or develop relationships with other people in the field that they weren't familiar with previously. But it's still their responsibility to follow through, no matter who the contractor is, to do their job. It's the responsibility of each individual in the system to do their job. The judges have to do theirs, the prosecutor has to do his or hers, the GAL, the guardian ad litem, must do his. The parents' attorneys have their responsibility in what they're representing for their clients. The agencies have their responsibility. So it's a matter of whether it's privatization or whether it's state operated. You each have your own role and your own professional and personal responsibilities to the job that you're doing. And if you can't focus on that, then maybe you ought to look for a different job.
Yes. I can,
Okay.
secondly,
I have
yes.
a question. Do you guys see that, that the guardian items, the CASA volunteers, the caseworkers, that they investigate more because the people that are providing the services, they're the ones that are signing off and saying that these goals have been met in the case plan? I mean, I'm just wondering, you know, if there's more investigation to see whether or not, yes, you know, the parenting class has been done, yes, you know, those kind of things. Because there's an incentive that, you know.
There was, we found initially the lawyers had to do some more questioning because reports were coming in that said such and such a service had been offered. Well, it had been offered 7 days before the review hearing. Not, you know, so those kinds of questions, initially, it was important to say, well, when did you offer this? Or when was this evaluation done? It was ordered 60 days ago. When was the appointment made for it? Once the expectation was clarified, that has not been so much of an issue. I think periodically, we'll throw one of those questions out. Periodically, I'll throw one of those out just to kind of shake everything up, just like I will throw out to a guardian ad litem every now and then. When did you last meet with your client outside the courtroom? And then the word gets out, oh, she's on that rampage again. But generally speaking, it's not an ongoing issue now. But to get that, a lot of these workers had never been in court before. They had not been part of this part of the process. They had no idea what the expectation was. We did not have a transition period. So there was no pre-training for them. Literally, they got the files and came to court. So it's all vastly improved since then.
There was a question here first.
Under your system, who makes the decision as far as whether you provide some special services like some child care deal diagnosis facility or something? We have a star code in Nebraska called John. Under your system, does the private contractor make that decision or does the state of Kansas make that decision? Because we have no problem. It's going to start costing a lot of money sometimes. We believe that safety services is sometimes particularly, and the courts have a hard time when they think something needs to be done. We have a hard time order.
Well, we kind of worked through that. We kind of got to the point where if we don't order this therapist, this treatment, this, but we say this shall be provided. And it gets down to a point where there's even in cases in Kansas say we can direct that a specific provider is gonna be the one that provides it, we let the contractors deal with it first. But if what they're doing is not meeting the child's need, we can step in and say, you shall.
What I tend to do in orders is say for a future reasonable efforts finding, the court will consider whether or not the following things have been done. And if they haven't been, and they can't come into court, as Jim said, and set out, well, we didn't do this because we later found out this, and this, then I'll make a no reasonable efforts finding. And if one of the things you think that there are things that need to happen with the child in state's custody, who's in place at Magellan or whatever, however you term that, I think you could use that same sort of language. Because mental health services are also under your HHS umbrella. They're technically responsible for all of that as it relates to kids. And they need to figure that out.
You have a question over here?
Yeah. Have you noticed a difference pre-privatization and post-privatization with maybe some of the more vocal children that are in court? I mean, how do the kids like it? Do they feel like they're being provided for better? Do they speak up and say, I really feel like I'm getting the services I need? Or are you just not really get that from it?
If you get those kids that have had multiple workers, they don't feel very good about it at all.
That happened before, too. That happened before privatization.
And that's really their focus. I get somebody who's, I don't even know is now my worker, has never talked to me. That's the same as it's always been. That's their focus, is having somebody to deal with.
Jerry?
One last question for those that have been on the bench long enough that you had previously when your services as compared to now. Which do you like better? I've been on the bench 38 years, and every 6 years, HHS will reinvent themselves. So which do you think was better services for the children, our most precious asset?
I would like to think that privatization has brought a better, consistent level of delivery to children who are in need of the services that the state can provide. And I think, generally speaking, privatization has been successful in that regard. It's not without its faults. It's not a perfect system, but compared to the state-operated system for the time that I was on the bench until privatization occurred, at this point in time, my sense is children are getting better services in a more timely fashion when it was operated solely by the state.
And I would agree that more children, and here's the goal, are achieving permanency. And part of that is probably privatization. Part of that is when the Adoption and Safe Families Act came into effect, it all sort of happened at the same time for us. So it's probably a combination of things, but I would say that more kids are in permanent homes faster and safer than
I've seen
before.
the length of my cases has gone down. But you just stop and think about it. Before we had this many SRS workers, now we've got this many SRS workers and these many contract workers. So if nothing else, you got more people paying more attention to the kids.
Probably a last question here. Is there anything else that you would, any other suggestions you've made for judges or attorneys or other people who are going to be involved in the child welfare system regarding the issues on privatization?
I'd like to say, and Jim brought it up earlier, and I think for you judges out there, meet with your private contract caseworkers. Tell them what's expected. Unless you want to be totally frustrated on a regular basis, they need to know that you're going to hold their feet to the fire. If you made an order and it wasn't done, you're going to call them on the carpet about it. And they need to be able to respond. They can't come to court and say, I didn't bring my file, or I don't know.
I just got this case yesterday.
I just got it. If I read the file, they can read the file.
And you need to emphasize to them, you are my eyes and ears. I make better decisions when you do better work.
encourage them to demonstrate a level of professionalism. It's what we are. We're professionals in our field. Act like it.
And credibility is the key. I've got workers that they walk into my courtroom, and again, I'm lucky. I've had consistency in the workers I have. They walk into my courtroom, they tell me something, I take it to the bank. I've had that kind of relationship with them that I know, and when they tell me, I believe it. And so to get that kind of communication going, invaluable.
I think one of the hardest things for our workers, which is a silly thing, but they took it all so personally. And I think it's important in the training to help these people know that it's not directed at them personally. It's a systemic issue. Otherwise, just take a deep breath and
Just go ahead and jump off the bridge.
Any final last quick questions? Let's give these guys a big hand.